Hello, I'm Blair Adams from Winkworth Sherwood, and in the next 15 minutes or so, we're going to look at some of the fundamentals of hybrid working. I assume you're watching this because your organisation is looking at implementing a permanent hybrid arrangement. So you're somewhere on the scale between those that want to return to full-time 5-day-a-week office-based working, and those, on the other hand, who've been very open and embraced a kind of work anywhere, work anytime arrangement. Now, as an employment lawyer, I know from experience dealing with flexible working in the past, as we used to call it, that flexible arrangements have often been the source of tension, even disputes. And I think that was for two reasons. Firstly, the rules around the flexible arrangement were not clear enough, they were not detailed. And secondly, there was a mismatch of expectation between what the employer wanted out of it and what the employee needed out of it. Okay, so the first thing I'm going to look at is laying down the rules of hybrid working, because the fundamental of any arrangement should be a very detailed policy that governs how it operates. And the first thing in that, of course, is to design your model. What are you offering? And it doesn't have to be one offering to the whole workforce. You may offer different arrangements to different parts of it or different individuals. But you've got to be very clear. Is it 3 days a week at home and 2 in the office? Is it that you can work at home 50 days in a year? Is it that you can work at home 30% of your overall working time? Whichever it is, you've got to really nail down the detail. Let's take an example. Let's assume my arrangement is I have to be in the office 3 days a week and I can work from home 2 days a week. So, first question, is my attendance at the office compulsory? Expected answer, yes. In most cases, it's going to be. But on the other side, do I have to work at home 2 days a week? Or could I decide to go into the office? Well, I guess that depends on your facilities. That if one of the reasons you're implementing hybrid working is because you've reduced your office space, then you may want to insist that I take those days at home, unless you tell me otherwise. And let's say 1 week I work 4 days in the office instead of 3. Does that mean that I get an extra home day that I can take the following week or month or sometime during the year? And equally, if I work more days at home than I'm meant to, do I have to make up office days the following week, etc.? And if I come into work in the office because you ask me to, rather than because I do so on a voluntary basis, is that different? Do I still get a home day to make up, etc.? You know, if I'm asked to come in for an important client meeting or whatever, what are the rules? These are the things it's very wise to lay down in detail in your policy. Linked to that, of course, is the question of working hours on a specific day. Most organizations have had some sort of working hours arrangement, even built around flexi time for people coming into the office. But what's your policy going to be when people are at home? Are you even going to have working hours at home, or can they work whenever they like? Think about what suits you. You know, do you need them to work in times that are aligned with their colleagues, perhaps in other locations? If so, then you'll need to set that out to make the expectation very clear. I think the next issue to cover is place where people work when they're working remotely. During COVID, we've all kind of muddled through to an extent. We've been working at home, you know, some better than others, but we've had people working on wonky chairs and dodgy desks and creaky kitchen tables. And we've generally sort of got by, and because it's been viewed as a temporary thing, we sort of put up with it, both on the employer side and the employee side. But if it's going to be a permanent long-term arrangement, is that good enough? Now, as an employer, you've got an obligation to make sure the place of work is safe, and that extends to the home workplace. And I assume you've all been satisfying that obligation by asking employees to do surveys, fill out questionnaires, respond to questions, etc., etc. You've also got an obligation to provide the equipment they need to do the job. And maybe this is the time to think whether you actually need to invest more in that, because although you may have given them the minimum equipment to work effectively or from home, maybe they could do better if they had the equipment at home that you gave them in the office. I'm sure these things have been on your mind already. But let's also think about what the remote location is. If by now my home is a decent working area, so I have good facilities, I have quiet, I have a stable broadband connection, I have some confidentiality, okay, I can work interrupted and effectively, that's great, that's good. But what happens if I decide to go and use one of my home working days working in a coffee shop, where my computer screen can be overseen, documents on the table can be read, my calls can be heard, I'm using non-secure public Wi-Fi. Is that acceptable to you as the employer? It may well not be. So these are the things you have to set out in your policy. When you are remote working, where do you have to be? And do you need permission to work anywhere else? I guess an extension of that is the fact that during the pandemic, some people have decided to go and live abroad, but still work remotely from an overseas location. Fantastic in most cases. For you as the employer, obviously you've got to get over the issue of whether that actually works in practice and is an effective solution. But from a legal perspective, there are other issues too. You have got to ensure that you understand which tax and social security system that employee falls under. And to some extent, the rules may have changed after Brexit, depending on where the employee is located. And you should also be satisfied that the person has the right residency or visa requirements for the country they're working in, because that could fall to you as a legal obligation as well. So whilst I know that some employers are introducing a work from home policy that allows up to 90 days working abroad, just make sure you understand the legal basis of that before you allow it on a widespread or an individual basis. So let's think about other policies now around just the hybrid working arrangement, because you'll have lots of policies already, and lots of them will refer to the workplace, and they'll be geared to what happens in the workplace. And sort of implied into that is the fact that the workplace was one place or a series of fixed locations. That under hybrid working is no longer the case. You now have a dispersed workplace with lots of different locations of potentially different types, including people's homes. So you need to be very clear, firstly, that policies extend to all those locations, whether you're present physically or virtually in them, and that they're appropriate for the sort of conduct that could occur. Because whilst certain types of conduct in the workplace often happen one-to-one on a one-to-one basis and was clearly inappropriate, it's just as possible for that sort of inappropriate behaviour to happen virtually. Think also about dress codes, for example. You may have rubbed along during COVID with people working in shorts and a t-shirt at home, and we've all sort of not minded very much, and there's been a very diverse individual approach to that. Going forward, post-COVID, you may feel it's better for your organisation to impose a clear dress code. So that may mean that people have to wear similar clothes whilst working remotely to what you require them to wear when they're in the office. Let's just talk for a minute about benefits as well. In many cases, benefits are linked to the place where an employee works. So, for example, they may have received a travel loan, they may get subsidised membership of a local gym, they may get discounts in local shops. Fantastic. But are those still relevant if people aren't working in that location so much or at all? And that's not so much a legal issue. It's more about making sure what you're offering is relevant to the way people are working, I guess, for recruitment and retention purposes. Now, if we look back at all the things we've just discussed, so from place of work, hours of work, location, etc., benefits, those are often all key elements of an employment contract, and some of them are mandatory elements, as you know. So when you are changing these and moving to a very different sort of working, I think it's really important to make sure your contracts reflect this. And in some cases, you may decide to develop a particular form of contract for hybrid workers, which I think is a very useful idea. In others, you might just vary their current contracts But whichever you do, make sure that the changes you are making, that you are allowing them to have or imposing on them, are recorded in writing and agreed. That's the basis of any good relationship. So you go into hybrid working, you've got the rules all set out. It works pretty well for most people. But what happens if you find a bit further down the line that it's not working for one individual or a certain team, or maybe it's not working at all, maybe it's just something you don't want to do anymore? How do you go back from it? Bearing in mind that if you set it up in the first place, you will have made changes to people's contracts of employment. Well, I think the two key things here really. The first is to understand that if you want to go back to some different arrangements, not hybrid, you will again be making changes to people's contracts. And the scope to do that is sometimes limited by the requirement to be reasonable. But it's where contractual clauses like mobility clauses, like flexible hours clauses, can really be important because they can give you a better platform for making the change. So it's important to try and build those things in if you haven't got them already. I think the other thing is to be clear what you would go back to. So whether it's on an individual or a workforce-wide basis, if you're bringing one hybrid working arrangement to an end, you've got to be clear what you want to replace it with, whether it's full-time office working or some different hybrid arrangements. And there's always going to be a question at that point as to whether you can make the employee change or not. And that's something I would suggest you take advice on because so many other factors come into that rather than just what is in the contract, although that's a key element. So linked to that is just a reminder that even if you go into hybrid working, employees will still have the right to make flexible working requests because that right still exists as a matter of law. So you might agree a certain arrangement with them and they might decide it's not really working for them. So they put in a request to do something different. You've got to give reasonable consideration to that request. You've got to reply within 3 months. You don't have to agree to the request, but the whole thing just throws up the need to, I guess, build into your policy the potential to change. Because whatever you're doing, I think post-COVID, even if it's been pretty much the same as what you're doing during COVID, it's going to be experimental to some extent. On a slightly wider topic, I just want to mention finally childcare and discrimination. And there are a couple of elements to this. I have heard from clients in the past that they used to think that working at home was just a cover for childcare, filling in when the nanny was available or the husband couldn't pick up from nursery, whatever. It's probably true. I'm sure many of us have done it. The world didn't end, no one died, we got on with life, as long as it wasn't abused on a regular basis. But I think it's legitimate for employers to ensure that you now give employees a new right to work away from the office on a regular basis, that actually they're not doing that because they want to cover childcare. So that's something you might want to sensitively and subtly build into your new policy. The flip side of that, of course, is discrimination. And even before COVID, well, long before COVID, the tribunals in cases that touched on this readily accepted that women in society tend to bear a greater childcare burden than men. So in cases about changes to shift patterns, where women claimed this had a disproportionately adverse impact on them, the tribunal supported that because they accepted that's where the childcare burden fell. And studies during COVID seem to suggest that's only increased. So you need to be aware of this from a couple of angles, I think. Firstly, if you're imposing certain working patterns on people, particularly in shift environments, in atypical working hours arrangements, you need to be aware of potential childcare impacts. And secondly, I think as hybrid working begins to embed itself, and we see some people being in the office more than others, perhaps, or at different times, you just need to keep an eye on how the culture in the workplace is developing. I think someone would already say that because they have childcare responsibilities or pick them up more than men, they tend to attend after-work events, social events, client events, weekend events, less than men. If hybrid working exacerbates that, or even continues it, then women could legitimately claim that they're being disadvantaged by it. So I'm not saying it's going to happen. I think you should be aware of it. So there we are, 15 minutes is nearly up. I hope this has given you some really practical tips to put in place with detailed hybrid working arrangements. If you'd like to follow up with anything that we've discussed or any other topics, please feel free to get in touch, and I look forward to seeing you next time. Thank you very much.